first speaker is Mr. Ben Olbourne. He is an international arbitration practitioner and arbitrator with extensive experience across complex cross-border commercial disputes, acting in both counsel and arbiter appointments under major international arbitrator institutions, including ICC, SIAC, LCIA, and UNCITRAL. He has particular expertise in international trade, construction and infrastructure, energy and natural resources, insurance, commodities, and shipping disputes. Based between London and Singapore through 39 Essex Chambers, Mr. Ben has worked extensively across Asia and regularly acts in matters involving multinational corporations, state-owned enterprise, and cross-jurisdiction dispute governed by a wide range of international laws. He has also been appointed as arbitrator in more than 40 international references across various jurisdictions and arbitral rules. Mr. Olbourne is recognized in leading legal directorates for his work in international arbitration and commercial dispute, and is noted for his strategic and practical approach to complex international matters. And with that, I'll give first the floor to you, Mr. Ben, please.
Thank you. Good morning and good afternoon, everyone. Thank you, Karana, for that introduction. And thank you to the BIAMC for the invitation to participate in this excellently themed seminar. I am truly delighted to be here today. In my initial presentation, I'm going to focus on sanctions and their potential impact on disputes. And I'm going to draw my examples largely from cases where financing has been at the core of the dispute. These examples are by no means exhaustive of situations where money gets stuck, but hopefully they are instructive to an extent nonetheless. Before turning to the substance of what I plan to say today, it is, I feel, important that I give some insight into my background and I acknowledge how that may have influenced how I approach the issues I will consider, but also the scope of what I'm going to consider. Many of you will come from quite different backgrounds, and hopefully in the Q&A session towards the end of this webinar, we might have an opportunity to explore where that brings us differences and similarities. Firstly, I am a specialist back-end lawyer, in equal measure an advocate and an arbitrator. That means the earliest I generally get involved is when disputes are starting to crystallise, but more so when they've already crystallised and the parties have already taken up arms against each other. So I'm not a front-end lawyer. I do see lots of contracts, of course, but I don't draft contracts as a rule, and I don't act as a business or legal advisor in that sense to clients. Secondly, some of you will have picked up from my accent. I am an Australian trained but English qualified lawyer, and I'm a long-term Singapore resident. Whatever else these wonderful places may or may not have in common, they are all common law jurisdictions based on the English model. Now, that model is conceptually quite different from the model in most other countries, which is based on the Roman or continental civil law system, including, of course, Indonesia. However, in practice, in my experience, that distinction is rather less significant than it might seem. When it comes to international commercial matters and to the resolution of international commercial disputes, and arbitration in particular, my experience is that approaches and outcomes tend towards being quite similar, whichever legal system one comes from. Thirdly and finally, in my initial comments, I am going to focus on private law matters, on commercial disputes, and on contracts. I am not going to look at investment treaty dimensions, nor at any public or administrative law dimensions. So if we can move to the first slide. This is really just an outline of what I'm going to talk about. I'm going to start with a brief overview of sanctions, which is slide 2, please. Much of this will be very familiar to most of us, but it provides a backdrop for our discussion, so it is useful to cover it quickly. Sanctions issues arise in many different ways in the context of financing of cross-border trade and projects. It might be helpful to set the scene at the start to give some practical examples of the issues and disputes I have had in mind when putting my thoughts together for this presentation. Some of these are drawn from my own cases over the last 2 or 3 years. Others are drawn from important cases in jurisdictions with which I am familiar. I will return to some of the latter towards the end of my presentation. My ambition here is to give some flavour to the types of disputes that arise. There are, of course, very many other sorts of disputes involving controls, sanctions, and disputes in global finances. And perhaps, again, we can explore some of these later in this webinar. Turning now to those examples that have informed my thinking for this presentation. The first of those involves a voyage charter party between a Hong Kong company and a PRC company, a China company, for the carriage of palm oil from Indonesia to Iran in order to perform a contract for the sale of palm oil to an Iranian public body. The governing law of the contract is English law. Importantly, the contract is denominated in US dollars. The charter party includes a provision that the charterer may request the owner of the vessel to reissue bills of lading, deleting any reference to Iran. Transmission of bills of lading is, of course, or transmission of bills of lading through banking channels is, of course, a necessary part of obtaining payment under a sales contract for international sale of goods. Now, in this case, the owner of the vessel did not perform the charter party, and the rights and the wrongs of that default are the central issue in the arbitration. However, the owner also says that the charter party was illegal and therefore void from the start because the provision allowing for reissuing of bills of lading without reference to Iran was for the unlawful purpose of avoiding US sanctions on the financing of transactions in US dollars with Iranian state entities. Another and quite different example involves a Russian oligarch who owns a fleet of helicopters which are housed in the European Union. And they're owned and managed through a corporate entity based in the UK. The individual became designated under UK sanctions. So too were his aircraft. Now, he accepted that situation without issue. But the question arose whether he could transfer money into the UK in order to continue to pay his pilots, his engineers, his security guards, and even the tea lady who worked in the office in order to ensure that the aircraft were maintained, not used, just maintained. In another aviation case, but one relating more to guarantees and security, a Russian bank had issued standby letters of credit to secure lease obligations of Russian carriers to the Irish owners of the aircraft. Now, the letters of credit had been confirmed by a UK bank. The leases and the security had all been issued well before Russia's military action in the Ukraine and the subsequent sanctions for that conduct. The Russian carriers then defaulted on the lease agreements, and the Irish lessors sought payment under the letters of credit from the UK bank. However, the bank declined to pay out under the letters of credit on the basis that it was prohibited under UK sanctions from making payment as the security was concerned with Russian aircraft. Now, my final initial example is concerned not so much with the financing of transactions, but with financing of the dispute resolution process. And what might happen with a Singapore-seated arbitration that has been commenced by a Russian entity that subsequently becomes sanctioned, with the consequence that it can no longer pay its lawyers, it can no longer pay the arbitration institution, nor is there any prospect of it being able to satisfy any award that might be made by the tribunal. Could the arbitration continue, or would it have to be terminated? So these are just some of the types of disputes I had in mind when preparing these comments. Now, back to the overview. If we could move on to the next slide, please. Thank you. So starting at the very beginning, what are sanctions? Well, we all know this, of course. They are restrictive measures imposed by international organisations, regional organisations, or individual countries. They are intended to be a diplomatic, non-violent foreign policy tool to pressure governments or organisations or persons to behave in a way that the imposing entity considers to be more conducive to global peace and security. Now, of course, it is often said that some sanctions are imposed for less noble and perhaps more self-interested reasons, but that's a discussion for some other time and place. There are many different types of sanction, but the key ones are listed under the 4 points on the slide. The first is financial sanctions, which can include measures such as asset freezes, restrictions on access to the international banking system, and access to insurance markets. A second form of sanction are trade restrictions and embargoes. These can be bans on the import and export of specific goods, such as weapons, technology, oil and gas, even in some instances, luxury consumer goods. Such sanctions may also extend to what are known as dual-use technologies or goods. These are goods or technologies that can potentially be repurposed from normal commercial usage into the development of military material. The third form of sanctions are sectoral sanctions, which target industries like defence or banking sectors in order to limit access to global markets. And some examples of these that are very current are sanctions on the Russian energy market and aviation market. And the final form of sanctions are personal sanctions, and these are bans that restrict the movement of designated and or their ability to access their funds and property. There are many different types of sanctions regimes. It is essential to be aware of. The most important ones, of course, are the US, the European and UK, the United Nations, and of a slightly different sort, China and Russia. And I'll come back to why I say they're slightly different in a moment. The most significant and far-reaching regime is, of course, the United States regime. US sanctions will apply to persons and companies who are subject to US jurisdiction, even if the transaction in question has nothing to do with the United States. A person will be subject to US jurisdiction if they are American, if they are organised under American law, or if they are located within or operating from the United States. There are extensive rules as to what qualifies as a US company for these purposes, including an entity or joint venture that is 50% owned by a US person. A person may also be subject to US sanctions if exporting controlled US origin goods or services, even if the transaction is not otherwise connected to the United States. These sorts of sanctions are known as primary sanctions. Many US sanctions are targeted at sectors such as finance, energy, and defence. If the transaction in question has nothing to do with the US, then one might think that United States sanctions are irrelevant. But that is not so, because so much of international trade and finance is conducted in US dollars. Since most, if not all, payments in US dollars have to be confirmed through a correspondent US bank, even if the transaction has nothing otherwise to do with the United States, and that US bank is subject to sanctions, it is not permitted to process the transaction that is denominated in US dollars. Thus, there are secondary sanctions, sanctions which affect parties and transactions not otherwise connected with the US, simply because their transaction is denominated in US dollars. Very quickly, the EU sanctions, upon which the UK sanctions are based, are closely based, generally apply only where there's a territorial or personal connection. Otherwise, in substance, they are closely aligned with the United States. UN sanctions are more limited. They focus on terrorism and the proliferation of weapons of mass development, and do not typically have the same sort of territorial and sectoral expanse as the other sanctions I've just spoken about. I just mentioned briefly here that there are now detailed counter-sanction regimes in China and Russia in particular that are intended to respond to what is considered to be the unlawful and exorbitant extraterritorial impact of US and European sanctions. I'll come back to those in a little while. Now, sanctions are a very blunt instrument. They are typically of general application and are intended to be interpreted and applied broadly. However, there is a need for flexibility, of course. So sanctions regimes incorporate provisions allowing for the grant or dispensation of exceptions or licenses. And these fall into two specific categories. They can be general licenses, which apply generally and do not require a party to make a specific application. One such general license, with which I'm particularly familiar, is that sanctioned persons are to obtain legal advice about their compliance with sanctions. And those giving that legal advice are able to give it. Another is in relation to certain forms of insurance, particularly third-party insurance. There are also specific licenses which can be sought in respect of what would otherwise be sanctioned conduct. For example, in the case I referred to earlier about the Russian oligarch who owned a fleet of helicopters, we ultimately sought a license that he be permitted to bring funds into the UK and that he be able to pay his pilots and his engineers and his maintenance people to maintain the aircraft in the UK. I now move on to the next slide, which is the start of my discussion of sanctions in the specific area of disputes. And there are two limbs to this. The first limb is that sanctions can arise as the very subject matter of the dispute. And this can be in many particular aspects. It may be because the intended contractual performance has been impacted by the sanctions. The intended contractual performance may become physically impossible. It may become financially impossible, or at least something rather more difficult to perform financially than was originally intended, or the performance may in fact become legally impossible or illegal to perform. And this may be because either directly, that is, one of the parties or the transaction itself or the goods themselves have become subject to sanctions regulations. It may also be indirectly because access is lost to funds or currency or to the necessary correspondent banks required to assist with payment. There can also be disputes over the interpretation and application of express terms in a contract dealing with sanctions. And these can include default and termination clauses, force majeure clauses, potentially material adverse change or material adverse event clauses. And also, and what we are seeing more and more frequently nowadays, are specialised or bespoke sanctions escalation clauses. There can also be disputes over the application of principles of general law, including principles of frustration, which is well known in the common law, and the principles of hardship and good faith, which are rather more known in the civil law than they are in the common law. And there's a wide range of potential claims that can be brought where sanctions are the subject matter of the dispute. These include claims for wrongful termination, claims for default, claims for damages for non-performance, claims for refunds of advance payments that are made before sanctions have affected performance, obviously claims in relation to goods, and also, and even more so in the civil system, claims for price revisions, extensions of time, or adjustments of other obligations to take into account hardships that are being suffered as a result of the sanctions measures. Can we move on to the next slide, please? The second way in which sanctions and disputes come together is where sanctions impact upon the process of dispute resolution itself. And this can manifest itself in a number of ways. The first is that sanctions may impose a restriction on access to legal services, to lawyers, to other advisors, to expert witnesses, amongst others. There may be bans on dealing or having any dealings with these persons. There may also be, as a result of sanctions, difficulties in obtaining necessary evidence. There can be travel bans imposed which prevent lawyers obtaining the evidence they need to help a client, or on witnesses travelling to give depositions or to give evidence at hearing. And there can also be bans on the transferring of data, including documents necessary to support a case. Sanctions can impose difficulties on the conduct of cases through arbitral institutions, because arbitral institutions, such as the one with which I'm most familiar, being based in Singapore, the Singapore International Arbitration Centre, but the Bali Centre who are hosting this would be another one. They will be subject to the general law and will still need to be satisfied that they can provide services and receive funds from parties who may be subject to sanctions. In addition to these physical or practical restrictions, there may simply be restrictions on the ability to pay for legal services. But there are general and specific licenses that cover payment for legal fees. For example, the United Kingdom has a general allowance allowing for payment of arbitration costs up to a specified sum, which I think is still £500,000. Payment of legal fees above that sum requires an application for a specific licence. And potential issues can also arise as regards the enforcement of any arbitral or court decision. And a distinction is drawn between the litigation of the dispute, whether in court or in arbitration, which may be able to proceed, and enforcement, which may not be able to proceed. Indeed, there is an important case going through the Court of Justice of the European Union at the moment on that specific distinction. So I'll move on to the next slide. I have referred briefly already to counter sanctions, and this is an important topic, albeit one that I can only deal with quite briefly. I do have a particular interest in what is known as the conflict of laws. This is where a dispute involves issues arising at the same time under two or more different legal jurisdictions, often where the application of those laws may be in conflict. And a very stark example of this is the appearance in recent times of counter-sanctions regimes, particularly in China and Russia. These jurisdictions have responded to the expansive, potentially exorbitant or excessive scope of US and EU sanctions by implementing blocking or countering sanctions to limit or reverse the impact of those sanctions regimes on their own nationals and businesses. And I've listed on the slide three of the more important examples of these measures. Could I move on to the next slide, please? Now, I want to come back to some case examples to give more flavour to how the issues of sanctions can impact upon global finance. And I'll try and take these very briefly. These are all cases from leading courts. The first one is the decision of the UK Supreme Court from 2 years ago in RTI and MUR shipping. This involved a contract of affreightment, which is typically a contract for a number of consecutive charter parties, which provided for payment of freight in US dollars. In 2018, the United States sanctions authorities included the charterer's parent company on its sanctions designation list. As a result, it was understood that the charterer would have problems making timely payment of freight in US dollars. Interestingly, in this case, it was the owners who then declared force majeure. And the charterers rejected the notice and offered to pay instead in euros and to cover any additional costs and exchange rate differences and so on. But the owners refused that offer, even though it was accepted that the owner's bank would immediately convert payments in euros into US dollars and credit the owner's bank account in US dollars. Now, the key issue in the case was the interpretation of the particular wording of the force majeure provision in the contract in light of sanctions. But the general takeaway is that the owners were not required to accept non-contractual performance, i.e. payment other than in US dollars. Second case is one of the cases I referred to earlier. It's the one relating to standby letters of credit issued by a UK bank in favour of Irish lessors of aircraft for the benefit of Russian lessees. The details of the decision turned on the wording of the UK sanctions regulations, but the decision has significant consequences, including for the structuring of trade finance facilities and for the performance of guarantees and other security-related mechanisms. Standby letters of credit, such as those used in that case, are typically used to manage risk allocation and to mitigate credit default risk. However, the decision in that case was that the UK bank did not have to pay out under the standby letters of credit. So that decision raises real issues as to a common practice for risk allocation in international financing arrangements. Can I move on to the next slide, please? The third of the cases I refer to here involves the same bank, but a different set of disputes. And there were, in fact, a series of cases which really showcase the potential for battles between English and Russian courts of the sort I referred to. In these cases, initially, the English courts were asked to issue an anti-suit injunction in support of a Paris-seated arbitration to enjoin a Russian entity from pursuing proceedings in Russia. The English court, for reasons we don't have time to go into, issued the anti-suit injunction. The Russian entity then petitioned the Russian courts for an injunction enjoining the Paris-seated arbitration, which, unsurprisingly, the Russian courts granted. So ultimately, there were injunctions in England seeking to prevent the Russian proceedings, and proceedings in Russia seeking to prevent the underlying arbitration. Ultimately, UniCredit, the party that petitioned English courts, went back to the English courts and asked English courts to revoke the English anti-suit injunction because they were concerned about the sanctions they might face in Russia. And the final case I refer to, DRL and DRK, was another one of the cases I referred to at the start. The substance of the dispute is not relevant. What is relevant is that after the arbitration was commenced, sanctions were imposed on the applicant that prevented it from paying the arbitration institution and from paying its own lawyers. It was ultimately unable to continue the arbitration. The tribunal made an order terminating the arbitration, and that order was ultimately upheld by the Singapore courts. In the circumstances of the case, that was fatal to the Russian party's ability to seek any relief at all. The final slide deals with some practical tips. However, I think we're going to cover many, if not all of those in our later discussion. So I'm not going to say anything more about those. I've taken up more than my share of time, and I do thank you for your patience.
Thank you, Ben. That gives us a very clear map of the sanction landscape and how it fits into disputes, including the contractual mechanism parties, for when performance becomes impossible or illegal. From Ben's presentation, Ben took us from the fundamentals on what sanctions are, the different types, and the patchwork of regime from the EU, UK, and US through the United Nations, China, and Russia. He also then showed us that sanction bite on dispute in two quite distinct ways. The first one is as the subject matter of the dispute itself, where they go to performance through impossibility, hardship, or illegality, and where the outcome often turns on the contractual machinery the parties had to include, such as force majeure, material adverse change, and sanction escalation clause. The second one, a point of the easy to overlook, is the sanction disrupt the very process of resolving a dispute itself, because it can put the restriction on the access to counsel, evidence, and the institution, the ability to pay deposit, and ultimately enforcement. Ben also explained several case precedents. For example, in the RTI case, where the UK Supreme Court held that a force majeure obligation did not require a party to accept payment in different currency, so non-contractual performance to overcome a sanction problem. In the celestial aviation case, the court also read that UK regime very broadly, where it also hold a bank. It is prohibited for the bank from paying out under the letter of credit because the payment was in connection with a sanction arrangement. And then from the Singapore side, the case taken from the RL case were an illustrations of basically a process risk where a tribunal can actually terminate an arbitration as impossible because sanction stopped the claimant. So the claim was simply lost. And basically from this presentation, if I can put it in a sentence, was that almost all of this is better handled before the contract is signed than after the dispute arises. And in counterparty and country due diligence, in the sanction, choice of law, and forum clauses, and thinking about payment, security, and third parties, not just the primary obligation.